Your CEO, Michael Sonnenschein, has tweeted that Grayscale is suing the SEC, but so far, Grayscale has only petitioned the U.S. Appeals Court for the District of Columbia to review the rejection. So is this the first step towards a lawsuit? And I guess maybe you can clear up some of the confusion.
That's right. So this is the first step that starts off the lawsuit. Last night, we heard from the SEC that unfortunately, our application to convert GBTC into a spot Bitcoin ETF was denied by a final order. That is what created a cause of action for us to file this petition for review, which is with the appellate court of the DC Circuit. So that is right.
And so I guess the next question is, why does this merit a lawsuit? What's the main argument of malpractice by the SEC?
So this goes back to last October when we refiled our application to convert GBTC into a spot Bitcoin ETF. That kicked off a 240-day review period where the SEC invited comments in for reasons why they should or should not deny our application. Through that time, we saw over 11,000 letters come into the SEC, the vast majority of which were saying that they believe the SEC should approve our application. This is a product that has become the world's largest publicly traded Bitcoin fund. It represents tens of billions of dollars of capital, 3.4% of all Bitcoin outstanding. Nearly a million investors are in it. And these investors are saying, we want this vehicle to be more protective for us. And SEC, that's why we believe you should approve this conversion. Over that time, we had engagement with the SEC, but unfortunately last night we found out we were denied. And so that is the reason why we filed this petition for review, asking the appellate courts to review the SEC's decision and challenge that argument.
So the SEC has rejected a whole bunch of other ETF applications over the past several years. So as we ask every Passover, why was this application different than all other applications?
That's right. So I think one important distinction between our application versus some of the other spot Bitcoin ETF filers is that we have an actual product today. As I mentioned, there's nearly 1 million investors in it. It is trading tens of millions of dollars daily trading volume, representing tens of billions of dollars of investor capital. So unlike other applications, which were mere ideas on paper, we have an actual investment vehicle today that we were looking to make even more regulated. And in my opinion, it's really a missed opportunity on the part of the SEC to allow Bitcoin to come further into the regulatory perimeter. And so, the arguments that we really are expressing in this petition are the arguments that we have started through our letters with Davis Polk last December and then also this past April. And what it comes down to is that we believe the SEC is acting both arbitrarily and capriciously and discriminating against issuers by approving futures-based Bitcoin ETFs, but continuing to deny spot-based Bitcoin ETFs like what GBTC would be. And the crux of that argument is that,
nonetheless, what was the structure of this ETF that would have been different than the previous ones that were rejected? While you said that the difference is that GBTC is an actual product that's traded currently, nonetheless, in ETF form, what made it different than other applications that went before the SEC and that were rejected?
The difference is that it's an actual publicly traded product. It's the largest Bitcoin fund in the world that has actual investors in it, representing billions of dollars of capital and trading volume. So I think it's just a different consideration when you have an application in front of the SEC, given that one of their mandates is to protect investors. This vehicle, because it's not an ETF today, is not able to track its underlying NAV and is actually trading at a discount to its net asset value. What that means is that investors in this vehicle are being withheld from billions of dollars of value that they would be able to realize if it were able to convert into an ETF. That's just not an argument that other Bitcoin ETF filers were able to make. But regardless, we believe that the SEC should approve all spot Bitcoin ETFs because they've already approved futures-based Bitcoin ETFs. And that's really the crux of our argument. The fact that in the context of ETF approvals, both futures and spot-based products are two like investment vehicles that should be treated alike and that they both should be approved. And in the absence of that, we believe the SEC is acting both arbitrarily and capriciously and discriminating against issuers, which are violations of the Administrative Procedure Act, which is what governs how regulators govern, as well as the Exchange Act.
So There appears to be a major difference in worldview here because the SEC has largely claimed that they reject these kind of spot ETFs because they're protecting investors. And you're saying that this actually would protect investors more. This would provide more regulatory protection for investors. So can you break down that argument, like why you think that having a spot ETF is actually better regulatory protection for investors?
A spot Bitcoin ETF is better for investors because we're seeing investors are gaining access to this asset class regardless of whether or not regulators are going to approve these types of investing vehicles. We have investors going to offshore exchanges or investing with companies or protocols that might be less protective. What we're looking to do is bring our existing investment vehicle further into the regulatory perimeter through a spot Bitcoin ETF, which I believe is just more protective for investors that are otherwise getting their exposure elsewhere in less safe means. It's really a missed opportunity in this manner. And I want to also to say, I have respect and appreciation for the folks at the SEC that have been reviewing these applications over the years. These are difficult questions. And what we have here is just a disagreement on how they should be viewing this particular application. And that's why at this point in time, since we've been finally denied with our application, we have no choice left but to seek to go to the appellate courts to explain what we believe are really common sense and compelling arguments for why spot Bitcoin ETFs should be approved in the US.
But there's probably some sort of happy medium between, a spot Bitcoin ETF and then going offshore. I mean, what about just buying Bitcoin directly through exchanges? I just think it's important to articulate, what is it about a spot Bitcoin ETF that offers greater regulatory protection than just, buying Bitcoin the way many Americans already buy Bitcoin?
Yeah, I think it's really about investor choice. You have investors that will be completely comfortable getting their Bitcoin exposure directly, self-custodying or holding on a US-based exchange or elsewhere. But there's a whole host of other investors that want their Bitcoin exposure through investment vehicles like the ETF wrapper. We've seen that from the way GBTC exists today, which is an investment vehicle that is a security, has reporting, audited financials, trades on a OTC marketplace. Investors can buy it through their brokerage account. So there's clearly investors that want their Bitcoin exposure in this manner. What we're looking to do with the ETF conversion is make it even more protective for investors, which is what we believe they both want and really deserve.
Craig, I'm wondering if you could walk us through the calculus in choosing to petition the Court of Appeals rather than wait a bit and refile an ETF application. Wouldn't that be faster and cheaper, or do you believe that there needs to be regulation through litigation?
We believe that we have laid out very compelling and common sense arguments through our 19b4 application. We've gotten to a point where the SEC simply disagrees with us. These are conversations we've had with them over the years of why we believe that markets are ready for this type of product. And right now we're at a place where we can either refile application, although it seems like we would probably be received with the same denial order, or we can go to the court system to present those arguments and see if we can challenge it there and have the courts agree with the arguments that we're making. And we think that's the way the outcome should be. These are straightforward arguments, and we're looking forward to engaging with the appellate courts. We believe that they'll find them as compelling as we do.
What's the through line, if you will, in all of these rejections? What has the SEC said is the single biggest obstacle for why they won't approve a spot ETF versus a futures ETF?
Yeah, it's a good question. One difference that has been noted, which I really think is not a difference that should matter in the context of ETF approvals, is the fact that the CME Bitcoin futures are more regulated than spot Bitcoin because there is CFTC oversight over them. And while those are certainly additional types of regulations, in the context of ETFs, those futures and spot-based ETFs are both priced based on the underlying Bitcoin markets. So even if the CME futures are more regulated by the CFTC, that type of regulation is not the kind that would protect against certain types of potential fraud or manipulation that the SEC has been citing in the context of spot Bitcoin ETFs. And that's why I really say these are two like situations that are being treated dissimilarly.
They are, but I mean, wouldn't the logical result would be that they decide, well, you know what, maybe we made a mistake with doing a futures ETF. In other words, that if it's pushed, when push comes to shove, if the argument is, well, prove that this is prove that this isn't a manipulated market, and there seems to be a failure to do so. Wouldn't that ultimately lead to the SEC even reconsidering that potentially? Or, is this actually going to make things worse if push comes to shove?
What we believe is there should be equal treatment across all types of Bitcoin investing vehicles, whether futures-based or spot-based. The arguments that we're making today, we actually weren't able to make before the first futures-based Bitcoin ETFs started trading last October. That's the same date that we refiled our application to convert GBTC into an ETF. We believe the markets are ready for futures-based Bitcoin ETFs, as they have shown throughout the last year. These products are trading very well. Through the market hours, investors are able to get their Bitcoin exposure through that type of vehicle. But we also believe investors that want exposure to physical or spot-based Bitcoin should also have the option to do that through spot-based Bitcoin ETFs, like what GBTC would be.
So just following up on this through line question, and my understanding is that one of the through lines in the SEC dislike of spot ETFs is this accusation of market manipulation, right? We've kind of heard this term over and over again. Have they presented any evidence of that? And just what is your response to that in general? That's always been, something we've heard, that this is a market manipulation is a problem, and that's why they don't want a spot ETF.
If the concern is about market manipulation, then that's really a concern that would permeate both the spot and futures-based products. But the fact that we've already seen approval of futures-based Bitcoin ETFs, and important, it's under the same regulations that the spot-based Bitcoin ETFs would be approved under. So if that's a stated concern, then it would affect both types of products. And so you really can't treat them dissimilarly by approving one and not the other.
So I just want to follow up, because I think this is really important for viewers to understand. When you say that if the SEC were to approve a spot Bitcoin ETF, it would offer more regulatory protection for investors. Can you just tease that out a little bit? Because again, I think most people see this as more dangerous for, not most people, but some people see this as more dangerous for investors. This is kind of the SEC's argument. So could you explain why this would actually lead to more investor protection, and specifically what kind of investor protection would be afforded with an approved spot Bitcoin ETF?
Yeah, so today GBTC is trading on the over-the-counter markets, which is a marketplace that has protections and surveillance in place. It's an SEC reporting company, so it's filing 10Ks, 10Qs, audited financial statements. It's registered under the 34 Act. What becoming an ETF would mean is we would be uplisted to NYSE, which has its own level of surveillance and governance and protections, which the SEC even cites are additional oversight that ETPs would have. So that's one type of investor protection. As an ETF, these shares would also be registered under the 33 Act. So just bringing more regulation and more oversight over the product is something that we think investors really want and deserve.
So just finally, just some real talk here. I mean, is there any hope of this succeeding? Just because, right now, given the timing of this, obviously you've been working on this for a long time, but the SEC does not appear to be very friendly toward crypto right now. We're going to see probably a lot more regulation by enforcement going forward. We have, a bunch of scams that have just collapsed, not scams, but a bunch of problematic companies, let's say, that have just collapsed. What do you think are the chances of this succeeding, or is this more of a symbolic gesture?
Yeah, so just taking a step back to the engagement we have with the SEC to date, they have a difficult job with this new innovative asset class, and we continue to be impressed with the level of education and learning that they have gained over the last several years. These are difficult questions, and what we're facing right now in the context of Bitcoin ETFs is simply a disagreement on how existing regulations should be applied to our product. Yesterday, we received the final denial order, and so our next natural step was to take it to the appellate courts to continue to lay out those arguments that we've previously presented to the SEC. It's hard to put a chance on winning or losing, but we think we have very strong, compelling, straightforward arguments, and we look forward to engaging with the appellate courts on exactly that.